morning, everyone.
Good morning.
And we'll continue with the cross-examination of Lieutenant Ratzburg. Go ahead, Mr. Alvey.
Thank you, Judge. Lieutenant, do you have the exhibits that you had brought with you? Are those still all behind you? For instance, Julie Jensen's appointment book. Is that something you have with you? It was, but I think he was keeping it.
It's over there.
Judge Gibbs.
There it is. Thank you. I've returned to you, it's Exhibit 239, Julie Jensen's pocket day timer, correct?
Yes.
We have this. Is this on? Now, you went through this on direct examination, and there are a number of activities noted throughout the year in the appointment book, right?
Yes.
Did you follow up to see, at least in the fall of 1998, whether Julie Jensen was doing all the tasks that she put on her calendar or planned to do?
In what month?
Well, in the fall of 1998. For instance, if we look at October 10th, we have something called Timmy and Paige's wedding. On October 17th, we have Kim and Tom's wedding. And do you know, for example, if she went to those weddings?
I don't know.
You understand that sometimes people put things on their calendar that they don't get around to doing, fair to say?
Yes.
You were asked specifically about activities that were planned for December of 1998. Do you recall that?
I do.
Well, let me just begin with the week of December 7th, for example. If you could go to that page.
Yes.
Now, if we look at that page, Detective Ratzburg, maybe I'll have to take these sort of a day at a time. We have some activities on Monday, December 7th, right? We have a notation, Dad 74, right?
Correct.
Little Bears, right?
Yes.
You understood Little Bears to be the daycare for their youngest son?
I did not.
Okay. You saw Little Bears noted a number of times in this calendar, correct?
Probably.
We have Drake KYF at 4 o'clock on Monday, right?
Yes.
And that's noted on a number of different Mondays and Wednesdays, Drake KYF on Monday and Wednesdays, right?
It's noted more than once.
And you don't know whether these were things that were scheduled, say, way back in September for regular Mondays and Wednesdays and put in the calendar at that time, correct?
Correct.
And these are activities for her kids rather than something more personal for her doing, right?
Yes.
The Drake and the Little Bears.
Yes.
And we have book club on December 7th, correct?
Yes.
If we look at, just back it up, the rest of that week, on Wednesday we have more Little Bears and Drake. Those seem to be, again, regularly scheduled activities, correct?
Yes.
On Thursday we have French club, piano, right?
Yes.
That was for her son, was your understanding?
I believe so, yes.
That also was sort of a regularly scheduled event?
Likely.
Same with that Friday with Kids Castle, another regularly scheduled event, correct?
Yes.
And that's the date of Stiefel's Christmas party, correct?
Yes.
Do you know whether she had a plan to go to that Christmas party?
I don't know.
And the following week also seems to be, with the exception of a Stiefel Christmas party and some event on Tuesday morning at 9 o'clock, just the same sort of regularly scheduled events for kids, like Little Bears, Drake, French Club, piano. Is that right?
Yes.
The week of December 14th.
Yes.
The week of December 21st, we have Little Bears and Kid Castle, a notation that it's the last day of school and that the Packers play, but there's nothing else during that whole week of December 21st, right?
Yes.
No Christmas parties, no holiday parties, right? That week?
Not that week, no.
So the remainder of the month of December, there's a book club noted, but there's not much in the way of events for Julie Jensen personally, correct? From December 7th on?
Oh, I guess the Stiefel Christmas party on December 11th, looks like she planned on attending that.
Or it may be a notation that that's her husband's party. It's unclear whether she's attending or would want to attend.
It's in her notebook. I take it from there.
Well, let me. Let me invite your attention back to November 5th in the calendar, in Julie's day timer.
Yes.
And we have, it looks like a TWA flight, 9:30 to 10:48, correct?
Yes.
Followed by an entry for the Marriott St. Louis Hotel, correct?
Yes.
And then on Sunday, November 8th, we have TWA flight, looks like returning 3:55, 5:16, true?
Yes.
Those plane flights and the notation for the Marriott coincide with Mr. Jensen's statements to you about being in St. Louis when his wife was sick, correct?
Yes.
November 9th, we have Joe's carpet cleaning at 2 p.m., correct?
Yes.
And that coincides as well with Mr. Jensen's statement to you that the carpets were cleaned when they returned from St. Louis,
Yes.
when he returned from St. Louis, correct?
Say that again?
Yeah, that coincides with his statement that the carpet had to be cleaned when he returned from St. Louis, right?
Yes.
Let me invite your attention to September 28th, Detective. Are you there?
Yes.
There's a notation of apply to hospital with a question mark. Is that right?
Yes.
Do you know whether she worked at the hospital at all?
I do not know.
Do you know whether she applied to be at the hospital?
I don't know.
If you look at October 16th, there's a notion for volunteer. You see
Yes.
that?
Yes.
And do you know what that referred to?
I do not.
Do you know if she volunteered at the hospital for a brief time?
I don't know.
You don't know if she volunteered and then decided not to do it, correct?
I don't know.
Yeah, it's this probably is. Let me return defendant's exhibit 142 to you, Detective. And that's the recorded interview of Mr. Jensen, correct? The transcript?
Yes.
At pages 9 and 10,
Which, are you speaking of the bait stamp or the other page?
the other page, the page of the transcript.
Okay.
And let me specifically invite your attention to line 24, page 9. You state there in asking Mark some questions, I remember you telling me that she didn't do anything at all with the computer. You pretty much did. You see that?
Yes.
And moving to page 11, line 4, Mark clarifies that Julie did use the computer, right?
Say that one more time.
Sure. Page 11, line 4, Mr. Jensen clarifies that Julie Jensen did use the computer, correct?
Yes.
And then he goes on to tell you in lines 10 through 14 that she used the Quicken program, true?
Yes.
And in fact, Mr. Jensen did tell you that Julie Jensen was computer literate, right?
Computer illiterate?
Literate. He told you that she knew how to use a computer, right?
Yes.
That she knew how to access the internet, right?
Well, he told me she can access the Quicken program. Yes, that would be correct.
Well, he told you that she knew how to access internet information too, right?
Yes.
And he told you that she did, in fact, access internet information, correct?
Yes.
I'm going to ask you to bring out the items that you seized in 2004. It's another 15, probably around 230. It's this right here. Yes. Do you have those out now?
I do. Let me get it organized here.
You testified on last week, Detective.
Go
You
ahead.
testified last week, Detective, that on December 3rd, 1998, at the house, you seized Mark Jensen's daytimer, correct?
Yes.
That was a leather-bound calendar, correct?
Yes.
We looked at that last week, and it no longer has the leather binding because you returned that to him, right?
Yes. Yes.
And it has 3 rings in which you can put in replacement calendars for each year.
I don't know about 3 rings, but it was a binder.
Okay. may have been more than 3 rings, but you put in replacement pages so you can go from 1998 to 1999 and then 2000, right?
Yes,
You looked through that 1998 calendar, correct?
yes,
You were looking for anything you thought was suspicious, right?
yes,
You were looking for anything you thought was unusual,
yes,
and you only returned things that you didn't find any evidentiary value in, true?
at that time, yes, when I returned it.
In reviewing that 1998 calendar, you saw no notes from Mark Jensen describing any of Kelly Labante's lovers, right?
No, I don't believe so.
You agree that you did not find anything like that?
Yes, I agree.
There was nothing in that 1998 daytimer that you seized that related to anything about penis size, right?
Not that I recall.
That's something that would have been unusual that you would have taken some note of, right?
Likely.
That would have been unexpected, true?
Yes,
Then in 2004, you obtained a search warrant for Mr. Jensen's office, correct?
yes,
His former office. He hadn't worked there in over 2 years, correct?
correct.
What you had learned was that some paperwork had been left behind in his office, true?
Yes,
You decided that you'd take that paperwork and look through it and see if there's anything of interest to you that might relate to this investigation. Fair to say?
yes,
You went and took whatever personal belongings that he still had in the office, correct?
yes,
Ranging from photographs of his children, right,
yes,
to old calendars, correct?
yes,
And loose paperwork, right?
yes,
Exhibit 166 Exhibit 166 is made up of documents that you seized at that time in June 2004, right?
yes,
All those documents were from that seizure in June 2004, right?
I believe so.
And these are the notes that Mr. Jamboys was referring to about Kelly's past relationships, right?
Yes,
And these are the notes that Mr. Jamboys was referring to regarding descriptions of other men that Kelly had been with, correct?
correct.
Do you have the originals with you? I think you put them. Oh, okay.
These here?
Let's start with these, yeah. And I have here some items. Well, why don't I get these marked? This has been marked as Exhibit 265. These are some original documents that were photocopied and put in Exhibit 166. Is that right?
Yes,
And these were found together in this fashion?
they didn't have that clip on there. The clip is I put it on there to keep it organized.
Okay.
And
These,
this yellow piece of paper is where this note was found.
okay. One note has been pulled from the stack of notes,
Yes,
and we'll mark that separately in a moment. And at top, the first page on Exhibit 265 is a calendar page from June 13th, 2000, correct?
yes,
That looks like one of those calendar pages that would fit into a daily planner, correct?
yes,
And this is Franklin Covey, is that right?
yes,
The other pages that were stacked underneath that are memo papers with Mark Jensen's name and his company, Stiefel Nicholas, correct?
Yes.
There are several other calendar pages, or let's say daytimer type pages that are undated that are also included in among these notes, right?
Yes.
These notes were stacked along with some other paperwork that included printouts from an internet chat between Mr. Jensen and Kelly.
Yes.
The copyright date on this 2000 calendar is 1998.
Correct.
So copyright dates appear that they could predate the calendar by at least 2 years, correct?
Correct.
And do you know if the copyright refers to the style of the calendar as opposed to being a printing date?
I don't know.
Okay. Could I see the calendars, the daytimers themselves? These notes also were stacked. Well, let me get these marked. This is 2000. These notes that you found also were stacked with an old 2000 daytimer that's in a brown binding, correct?
Yes.
And a 2001 brown binding, true?
Yes.
In addition, there's some paperwork about Kelly's previous employment that appears to have been printed off a computer in September of 1999, correct?
Yes.
All of these documents that were stacked together, did you find anything that's dated before September 1999 in terms of when a note or calendar page is created?
The box is quite large. I did not find anything in particular, no.
Okay, so generally these are calendars from 2000, 2001. We have a printout from September of 1999, and we have undated notes that were stacked in the middle of all these items. True?
Yes.
Let me get this one marked too. Thank you. Last, I show you Defendant's Exhibit 268. That's a note that was within these other documents and is marked by this yellow slip from where you took it out. Is that right?
Council, may I see what you're showing? Joe?
Sure.
I see it, Mr. Alden?
This particular note is a note that includes a reference to someone named Jock, is that right?
Yes,
And that's the note that was taken out from this, where this yellow page is.
correct.
From a stack that starts with a calendar page from June 13th of 2000, right? And among the other calendars from 2000, 2001, and these internet chat transcripts. Those were all stacked up together. True?
Yes.
I move 266, 267, 265, 268.
No objection.
Steve?
During that recorded interview with Mr. Jensen on April 21st, 1999, after the portion that we watched, there's a portion where Mark Jensen is crying. True?
Yes.
Do you need to refresh your recollection by looking at the transcript?
Well, I object to any question concerning any expressions on the part of the defendant after the part that was shown to the jury, Your Honor. It's hearsay.
The objection is sustained.
Well, I'm asking for his demeanor.
Well, but
Later
demeanor
on.
demeanor can be hearsay. But in any event, the question was answered. So his memory doesn't need refreshment.
I move that it be stricken, Your Honor, because it was irrelevant and it's hearsay.
Well, I don't know if it's relevant or not, but it's hearsay. I talked about a statement, hearsay being a statement not made by the witness while under oath at the trial, offering evidence to prove the truth of the matter asserted, and I suppose that bears on the relevance because we don't know what the relevance would be, because it doesn't have any particular meaning at this time, so without meaning it has no relevance. And to the extent that it would have relevance, it's hearsay in the sense that if it were offered to prove some particular a response by the accused, the accused at the time was not under oath at the trial, so his statement is hearsay to the extent that it would be offered to prove any particular thing. And the reason you've heard some of his statements on the board here was because the opposing party is permitted to offer hearsay statements of any person. So the objection is sustained. You have a quizzical look.
Yes.
I misinstructed the jury?
Yes.
Go ahead. What do you?
Well, I don't think I should
Well,
talk about it at this stage. but-
come up. Oh, and here, I think we'll take a break anyway. Let's take a break. Please don't talk about the case during the break.
Please, all rise.
You got to note that one of the jurors needed a break, so to give us an opportunity to discuss this further. And why don't you restate what your concern was, Mr. Albany?
Well, the one concern I have is that we've had lots of hearsay admitted in this trial without special instruction. And to give a special instruction for the defendant and talk about how his statements weren't under oath when we haven't done that for any other witness makes it sound as though the defendant is a less trustworthy individual for his statements. And
Just so, I think, correct me if I'm wrong, but I think I did give the jury a general discussion about what hearsay was earlier on in the trial. And I said there were many exceptions.
Well, but there hasn't, I don't recall much in the way of like when some hearsay is admitted as to a particular defendant, and this is admitted because it satisfies, or has been agreed to by the party, it satisfies hearsay exceptions, and also additional parts would be admissible under the rule of completeness. And to point out that it's not under oath, or that somehow it should be, it seems to me that it communicates that it should be given less weight than the hearsay statements of other people admitted or any other evidence. I mean, it's admissible evidence. It's come into this trial. They decide what weight, and it's not less weight because it's hearsay. And we've not said as to any other evidence in this case. Every statement, out-of-court statement in this case was not under oath. And, well, I guess some of them have been. I mean, we've certainly gone through statements at prior hearings. But to specifically point out that the defendant's statements are not under oath and are hearsay, I think is communicating that these are less deserving of weight. The other thing is we've had a lot of testimony in this case, and maybe some I've objected to, but I think it's the kind of thing that often gets in, as to what somebody else's reaction is to hearing something. And that hasn't been deemed to be hearsay in this case. It's what their reaction is. And what I want to ask is, when he was asked questions, when Mr. Jensen was asked questions about whether he should have gotten help for his wife, he was crying at that stage. And that's not a hearsay statement. It's what his reaction was to a particular line of questioning. And that's what I want to get in. It's admissible as his demeanor, just as other people's demeanor has been admissible, and statements about how Mr. Jensen or others reacted to hearing some particular statement. So that's what I wanted to get into here.
Thank you, Mr. Jimboy.
Well, he's foreclosed from going into anything after page 140, line 15, by stipulation of the parties. We entered into, if you'll remember, the reason that page, that went from the beginning to page 140, line 15, and that was by stipulation and agreement of the parties. I didn't think that much was admissible, but just in the spirit of in the spirit of cooperation, I agreed to that. If there was a stipulation, that's all we were going to go into. So there's not to be any questioning whatsoever concerning anything that occurred, for example, on 140, line 16, because the stipulation was page 140, line 15. Now, in terms of here,
so I understand the scope of the stipulation. That's a little beyond what I understood. Are you suggesting, for example, if the defendant took the stand and it became relevant to show a prior consistent statement, that he would be precluded from offering?
No, if the defendant takes a stand.
So I don't think this bars forever the remainder of that audio videotape, but I do think you fairly stated in terms of this point in the trial.
No, and I will say something else. In terms of this hearsay notion, a statement by a party opponent is by definition not hearsay. And so when the state is seeking to elicit statements that the defendant made at any time, the test is relevance, not hearsay. It's a statement by a party opponent. It's not hearsay by definition. Now, there's still an issue of relevance. So I can seek to elicit any statement of the defendant whatsoever, and the only standard is relevance. However, the defendant does not have that option. Defense counsel does not have that option. The statements he was seeking to elicit from Detective Ratzburg concerning the defendant's demeanor at the time of this interview, sometime later after page 140, line 15, it is irrelevant. And insofar as it communicates anything, then while it may be relevant, it's inadmissible hearsay because it's not being offered it's not being offered by a party opponent. So
it's not being offered for its truth either. Crying.
Wait a minute. First of all, I think that's what I told them, although perhaps it may be in a long-winded fashion, but I was trying to tell them that to the extent that it proves anything, it's hearsay, and to the extent that it doesn't prove anything, it's irrelevant.
I didn't have any problem with what you said to the jury. I guess when I objected on relevance grounds and because it was hearsay, you said, well, it is hearsay, but it is relevant.
Well, you're right. But then I corrected, I thought, when I talked to the jury, and I stand on what I told the jury. I think it was a correct statement.
I think it was too. And in terms of any further cross-examination of anything that occurred after page 140, line 15, I object because it's calling for hearsay. It's seeking to elicit hearsay from this witness.
All right, and let me just say, in response to your statement about my drawing special attention to the evidentiary ruling pertaining to the defendant, I'm very sure that I've spoken to the jury before about what's relevant evidence, what's hearsay, and the reason I do that is I've been on a jury. And I know how jurors feel that they've been deprived of things by objection, so I do try to acquaint, I think I said this earlier in the trial, I do try to acquaint them with how the rules work, and that there's a good reason why they're not allowed to hear certain things. And I tried to do that here without indicating any bias one way or another, and your objection's in the record, but I think the instruction I gave was a correct one.
Again, I was particularly concerned about the statement of it not being under oath, which I think carries an implication that it's
I think I made that statement as to all out-of-court statements. And that there's an exception made in the case of I didn't say the defendant, I said an opposing party's statements.
Judge, as to the issue,
Which, as Mr. Jambois correctly states, is not actually an exception, it's an exclusion, it's not definitionally hearsay. Sorry, go ahead.
my understanding is stipulation is that's the only video that's not admissible, and that I've foreclosed any arguments about the rule of completeness bringing in additional portions of that transcript. However, this is not a declaration. That's what you have to have for hearsay.
Why are you offering? Then why is it relevant if it's not a declaration?
Because it's his emotional reaction to something. We've had
Which is a declaration.
No, I don't.
Well,
it's not offered for it's not offered for its truth. They can decide whatever.
Is it not true that if the, well, let me see. How do I want to say this? You would agree with me, would you not, that one can convey an assertion by means of well, to the extent that I suppose as I think about it, there may be some validity to what he's saying, because although the statement might be hearsay, there is an exclusion for the same reason I let David Jensen's statement in, then existing emotion.
Okay.
Even if but I think you're correct that it's beyond what the stipulation provided for. There may be a point in the trial when you could introduce this, and maybe I would decide that it wouldn't be hearsay, but this is beyond the stipulation, Mr.
And Your Honor, by the way, it's not even what you just said it was. There would be good reason for the most cold-blooded sociopath on the face of the planet to start crying at some point.
Of course there is. Of course there is.
For a variety of reasons.
It is an assertion, but that's not for me to decide. That's the jury. Then if I rule as you wish me to, then I would be making the decision for the jury as to the meaning of the weeping.
Your Honor, let's say that the defendant at the time of his wife's funeral or wake was crying profusely, and the defense wanted to introduce evidence to that effect. Would it be admissible? And I would say it's not admissible because it's no, the defendant was crying on December 3rd, 1998 when Officer Riley responded, and Officer Riley noted that in his report, and he was asked questions about it. We didn't object to it at that point, although there's no reason to think that was any more or less crocodile tears than any other of the defendant's tears. But, you know, it was very close in time and proximity to the police responding to his wife's death.
You know, let's go back to the statement about crying at the funeral.
Yes.
And you say that's hearsay, and you give an explanation as to why, which I don't think I can even necessarily buy into, although it certainly could be correct. But it's not an assertion of historic fact, which is basically what the rule which is basically what the rule of hearsay bans, is my recitation of an historic fact. If you read that weeping as being just a statement of a then existing emotion, it's not. It's not an assertion of an historic fact, so it probably is not hearsay. Or it's an exception to the hearsay rule. This is why I think the first thing I said about hearsay to the jury, and I'll say it to us lawyers too, is the first sentence in the book about hearsay when I went to law school was, there's nothing murkier or more confusing in the law of evidence than the hearsay rule.
Except for this. When the defendant says it, and I want to offer it, it's not hearsay by definition.
Oh, that definitely is correct. On that, there's no question you're correct.
Utter clarity on that point. And the defendant's decision, let's say it's a decision to start crying at some point when he's confronted after all this. He has good reason to start crying during the course of this interview. I mean, he's just...
Argue it. I mean, this is not
He's right.
Wait a minute. I get to finish my statements. I didn't interrupt counsel, even though I disagreed with what he was saying.
Go ahead.
And the fact is that this defendant's crying at some later point during the course of this interview, which is not coming in. The interview is not coming in. The fact that he started crying at some later point, he had been confronted with this letter that he'd never seen before. And he might be thinking, oh my God, I'm going to spend the rest of my life in prison. Although, you know, he's pretty stoic when he was reading through that thing over and over and over again. He wasn't outraged. So I believe that his expression at the time that this letter is presented to him, I think it's something both parties are going to argue in front of the jury. But what occurred after page 140, line 15, is not to be presented to this jury by stipulation of the parties. Now, if the defendant gets on the witness stand and he testifies under oath, and then he makes a statement that is, and I say, oh, you just made that up just now, and here there's a prior consistent statement, either because he said it to Officer Riley or because he said it to Detective Ratzburg. Prior consistent statements that are being offered to rebut an inference of recent fabrication, they come in. How does this come in? How does it come in at all? It's not relevant. It is completely irrelevant. The fact that somebody's crying 4 months after his wife's death, while he's being interrogated by the police, what does that mean? It means maybe he's trying to persuade the police again of his remorse, of his regret.
We're arguing about something that's actually not before the court right now, and I do agree generally with Mr. Albee's statement. You can argue it, what to make of it, but I think that we're all at the point where I am going to sustain the objection, and I'm going to leave the instruction as it stands because it's basically a correct statement, I think, of the law and the rule of evidence. But I will state that I do not embrace Mr. Gemboy's theories about this not coming up at a later point. Maybe it will, but the stipulation controls at this point.
Well, we've got an issue with the stipulation then, because my view is that it precluded playing the whole video. And I mean, I wanted the whole video, and so I mean, what we have is a compromise of the whole video.
Less than the whole video.
I understand. I'm not.
Less than 140 pages.
But here's what I don't believe the stipulation encompasses, is I have this issue about Aaron Dillard's knowledge. And I've already gone into other pages beyond 140 because those are all relevant to what Aaron Dillard knows when he looks at the transcript in Mark Jensen's cell. And so those pages are something that I intend to establish with Detective Ratzburg further exist, that there's other spots where Aaron Dillard can latch on to information provided by Detective Ratzburg. That from the transcript, not the video. They're not offered for their truth. It's just the source of knowledge from Aaron Dillard. And it's Ratzburg's, Detective Ratzburg's statements by and large, rather than what anything Mark Jensen says.
Well, the sobbing certainly is not something that Mr. Dillard would have picked up out of.
I'm not trying to put that in on that basis.
Well, I'll deal with those if and when they arise.
Well, those are about to come up.
Well, and then let's deal with them right now, Your Honor. And there's still not one whit of evidence that Aaron Dillard ever saw that transcript.
He states he's going to prove conclusively that Aaron Dillard had access, or that there was a transcript in the cell.
But he's not going to prove, first of all, maybe he can prove that there was a transcript in the cell. He's not proven that Aaron Dillard ever saw it. And how is he going to prove that? Is he going to have Mark Jensen testify that I showed it to Aaron Dillard? Because the only testimony on this point comes from Aaron Dillard. And Aaron Dillard says the only thing I read was Ed Klug's testimony. And furthermore, Aaron Dillard testified that he was in that cell block for only 2 days. And for most of that time, he was sitting there talking with Mark Jensen. And the only time he read anything was when the defendant gave him Ed Klug's transcript. That's the only evidence in the record.
Well, that's what he says.
I understand that's what he
It's the only
says.
thing up now, but what about this? You're promising what's going to happen that's going to suggest that Mr. Dillard may have seen the transcript of...
It was in Mr. Jensen's cell,
And?
that's all I need, because Mr. Dillard is a liar. I don't have to accept, just all I have to prove, Judge, is opportunity for him to have the information. And Aaron Dillard said he wasn't in Mr. Jensen's cell. You'll recall Dion Hardison said he was always in his cell. So, I mean, that's one more reason to disbelieve him. But all I have to show is opportunity.
What about that?
I don't believe that was Dion Hardison's testimony. I believe Dion Hardison said that he was always with Mark Jensen, that they sat against the back wall, or against the back wall in the cell block. Maybe Aaron Dillard went into the defendant's cell on occasion, but that's not what Dion Hardison testified to, I don't believe. I'll have to go back and look at the transcript of his testimony, or look at least my co-counsel takes notes when people are testifying, I don't, but I don't believe that was Dion Hardison's testimony. And the only evidence that we have concerning reading transcripts comes from Aaron Dillard and from nobody else. Now, if the defendant testifies, and if the defendant testifies that I gave Aaron Dillard the transcript of the interview, well then I think we could go into it. But we've not reached that point. So what was in the thousands of pages of documents that the defendant may have had in his possession is not relevant. It can't be charged to Aaron Dillard. When Aaron Dillard testifies, the only thing he read was 1 or 2 newspaper articles and the transcript of Ed Klug's testimony.
Well, what I think I'm going to do is to prohibit you from going into this material, because it does have the high potential of inserting hearsay of statements of the accused into the record at this point, and I'll permit you to call Detective Ratzburg as part of your case if you wish to present one to further deal with these matters at such time as they are non-hearsay.
Well, I certainly hope I'm not precluded by anybody accepting Aaron Dillard's statements as truth. All I have to show is opportunity. Nobody has to believe anything Aaron Dillard says, and I think anybody would be foolish to do so. I mean, if he is in the jail, the papers are in the jail. That gives him the opportunity, because the question that's been posed by the district attorney is, how could he possibly have gotten this information? You know why? Because the information was in the same cell block as you. That's how, Mr. Dillard. And that's all I need to show. And that's what I will show. Because even, and let me just hypothesize the situation. Even if, let's say Mr. Jensen testified and said, I didn't tell him, I didn't see him read that, I don't know how he did, but all you need to show is the opportunity. He's like, but it was there, so he must have gotten it. So, I mean, there are all sorts of, all I have to show is the opportunity for Aaron Dillard, and that I will show abundantly here.
Well, where are we at then? My understanding.
I wanted to see if you had any response. What materials do you want to bring in from the statement?
Well, there's material at 142, 143, 145, 149, 150, 51.
I only have up to page 140. I don't have the rest of it, so I got to find the rest of that statement before I know what counsel's talking about here. I'm sorry, counsel. So you at page 142, was that the first?
142, because there's discussion about rolling her. Page 143, because there's discussion about the head being in the pillow.
Let's stop there. Let's stop at page 142.
What do you want to say about 142?
this is where the defendant starts his story about suicide. So the question is, line 15 to line 20. I just think, okay, she's on her back, she's having problems breathing, okay, you possibly think there's something in her throat. Why not get emergency personnel there? Why not go that extra step? I mean, to me, this is a life-threatening situation. Okay, instead what you do is roll her. Now, if that's all he wants, if he wants to leave it at that, and just read that, and nothing else, fine, I got no problem. But you see, that's not where he wants to stop. Then he wants to go down to line 22, line 21. She didn't want me to.
Now, how are you going to tie that to Mr. Dillard?
If he reads a statement about rolling her?
No, if he reads the part about she didn't want me to.
I'm not trying, Mr. Jamboys can say whatever he wants about what I'm doing, but he really doesn't have any clue at all what I'm doing here, so.
Why don't you tell me, clue me in on what you propose, what lines you're going to examine him about?
I intend to do it just like I did with Dr. Mainland, Your Honor, which is I didn't read other things. I talked about rolling her, I talked about the nose being in the pillow, I talked about pushing on her chest, injuries to the chest.
Well, I don't want to hear what you did with Dr. Mainland. I want to know what you're going to ask this detective.
Okay, and that's it, is lines 15 to 20 on page 142.
Okay.
I have no objection to line 15 through 20.
Then page 143. Lines 12 through the first two lines of page 144.
Well, I object, because there's statements for the defendant in there. I have no objections to line 12 through 15.
Well, if line 16, he said, the question is, you know what I'm saying, answer yeah. Now, that's not damaging to the state. Go ahead.
Okay.
Let's see,
Well, then line 22.
Yeah, you can't put in 22, her robe was on the...
Well, Judge, I'm not offering any of Mr. Jensen's statements here for the truth. If Mr. Jensen, anything that Aaron Dillard could adopt is...
What did Aaron Dillard say about robe?
Well, he didn't. I mean,
Okay, then don't put it in. No, you're not going to put it in.
And that's fine. I'm just, in terms of, I don't want to get off on the belief that just because Mr. Jensen said it, it's not admissible. I don't have any problem with this line. I get nothing out of it anyway. The notion that I'm trying to sneak something through is preposterous on that. Page 1.
So right now it's page 143, line 12 to line 21?
Through the first two lines of 144. And we're taking out line 22.
Okay, so you want to pick up again at line 23 on page 143.
Right.
And then the first two lines of 144.
All right?
Yes. Well, Judge, if the court wants, either I can do this, I'll mark up exactly which lines we're putting in, and they can be reviewed, rather than going through it now.
Okay.
One by one. And either I can do that in recross or call Detective Ratzburg, but we'll have an opportunity to go through that. I mean, I have the
time if you could do that in advance, so we could see.
I have the pages marked out already. I don't have the lines marked out already.
I understand. Well, the lines may become important, and certainly aren't.
That's fine.
Well, do you want to excuse him from the stand and come back to your cross and do the other witness, or do you want to finish your cross and I'll allow you to come back to this on recross, or do you want to call the witness separately?
Let me finish Detective Ratzburg, and I'll plan on doing it on recross at the moment.
Any problem with that?
No, because there'd be a significant break before we put Marty Cook on, because he needs to set up some equipment in the courtroom.
Okay. All right, ask the jurors to come back in, please.
By the way, Greg, did you ever bring in the rest of those bait stamped pages?
I had them here like a bunch of days in a row. Because I'm not using them, I don't have them.
Bring them in this afternoon.
I'm not going back to the hotel. What do you need them?
Well, I just want to read them. I've been asking for them for a couple.